Introduction. We'll share now a presentation. If everything is okay, you can see now our slides. Okay. So welcome everyone on this webinar about your rental journey in Belgium as an expert. I hope you will enjoy it and you'll learn a couple of things about our country. So let's start. For today, in our presentation, it will be about the Belgian rental legislation. And in this presentation, I will provide an overview of the key regulations governing residential lease agreements. As you might know, Belgian rental law varies vastly across the country, 3 regions, and I will highlight these regional differences too. Our program is divided into 5 different sections, as you can see on the slides. And we will end, like Fiona already said, with a Q&A and some tips and tricks that might be useful. If you have other questions at the end of the presentation, you can always send me an email or phone me. You have all my contact details at the end of the presentation. And normally you have already the slides, or the slides will be shared after the presentation. Let's start with our first module. In this module, we will see the introduction, the scope, entry into force, and the common rules on the pre-contractual situation and the conclusion of the lease. Well, speaking about the pre-contractual situation, it's about all the publicity that is made for your rental lease. So let's see how it's about in these 3 regions. We start with an overview of the regional legislative bodies. So in Belgium, we have 3 regions. You have Flanders, Wallonia, and the Brussels capital region. So important when I speaking about Brussels, it's not the city of Brussels, but it is the Brussels capital region. It's the city of Brussels and the 19 cities around the capital. So that's important to know. If you have a lease agreement in Uccle, it's also part of the Brussels capital region. If you have one in Waterloo, it's Wallonia. If you have one in Rood-Saint-Genès, it's Flanders. So it's a difficult country for all our rental agreements, and that's why I will give you this presentation today. So each region has its own legal framework for housing rental laws. And each region has adopted its own rental legislation at different times. So the first we have, that's the Flemish Housing Rental Decree, the Vlaams Woninghuurdecreet. It came into force on January 1st, 2019, so 6 years ago. Flanders and Wallonia each enacted their own decrees. And in Brussels, it's not a decreed ordinance, but it's incorporated within the existing Brussels Housing Code. So if you're looking for the rules about Brussels for all the rental agreements, you don't have to search on an ordinance. You have to look into the Brussels Housing Code. Now, the location of a property, it will determine which regional rental law applies. It means that the applicable legal framework is based on the region in which the rented property is situated. So Flanders, it's Flemish Housing Decree, Brussels is the Brussels Housing Code, and Wallonia, it's the Walloon Rental Decree. Like I said before, watch out with Brussels. It's not only Brussels City, but all the cities that are part of the Brussels government. Okay, all 3 regional legislations apply to residential housing rentals and explicitly exclude tourist accommodations. The regions have specific legislations that applies to touristic accommodations. This is because residential rents, the lawmakers impose a lot more protection. So if it's a touristic house or apartment, you don't have to look for the decrees I will talk about today. No, you have to look at the decree specifically for tourists. Now, entry into force. That's an important one. I already said that we have 1st of January 2019 for Flanders, and Brussels, it was 1st January 2018. But there are differences into which law you have to apply on which contract. So in Flanders, a residential tenancy decree took force on 1st of January 2019, but it only applies to leases signed after that date. Leases signed before the 1st of January 2019, they are still remain subject to the previous Residential Tenancy Act. It was a federal law and it still applies still today to all the contracts that are signed in Flanders before the 1st of January 2019. The Wallonian rental decree took effect on 1st of September 2018. And then Brussels, the ordinance entered into force on the 1st of January 2018. However, there are 3 key rules that apply only to leases signed after that date. These rules concern information the landlord must provide, form and entry conditions of the rental agreement, and leases agreed upon orally. These are all things we couldn't get undone after that date. That's why only this kind of information we have to look at the old Residential Tenancy Act. But normally the rule for Brussels is if you have a contract, it doesn't matter on which date you signed the contract. You have to look for all the rules into the Brussels Housing Code. So all your leases for Brussels, look into the Brussels Housing Code. For Flanders, watch out for the date that you signed the contract. So it's either the Flemish Housing Decree or the old Residential Tenancy Act. Now, let's see the common rules for conclusion of our lease agreement. So we will see the pre-contractual information follows the residential lease registration and state of the leased property. Now, despite regional differences, certain general principles remain consistent across all regions. And we will now go through all the pre-contractual stages and what to look out for. So first of all, we'll talk about information a landlord has to provide to you when you sign the lease at the latest stage of the signing. And then we'll go to the form of the lease. We'll talk about documents you have to sign and all the extra attachments you have to attach to the signed lease. And then we'll see for the registration of a contract. And that might be a strange concept that is quite specific to Belgium, but no worries, I will explain it later on in the presentation. And then very important one, that's the condition of the rentals place. Let's start with our overview. So we have an overview here for Flanders, Brussels, and Walloon. You see for Brussels, there's a lot more information that must be mentioned in your publicity when you have when you make publicity for a rental space. That's all the information that must, at the minimum, be announced to. So before signing a lease, landlords in these 3 regions are required to provide clear and transparent information to prospective tenants. A written lease agreement is mandatory and must include essential elements like, of course, the rental price, the duration of your contract, and obligations of both parties. An agreement must be registered to ensure legal protection for both tenants, but also for the landlord. Now, since November 2024, so November last year, the list for Brussels is expanded. So Brussels has introduced even more information requirements for landlords to disclose. So you have to mention state of type of lease, or 3-year, or short-term, or 9-year. Habitable area, so the spaces that are mentioned to be rented. The reference rent, it sounds maybe weird, but it's a specific term for Brussels, and I will talk about it later on in the presentation. And also, very important one, for short-term contracts, so all the contracts under 3 years, you have to mention already in the publicity the amount of the last paid rent. Why is that? That is because if you have only short-term contracts, you can choose the rent you're asking. even if it's the tenant who ended the contract before, you can only ask for the same rent, and you can indexate it, but you can't ask for another price. It must be the same rent, only you can you can ask for the indexation. And that's why a tenant must see what's the last paid rent to see if it's you're asking for the right price. And that's why in Brussels they obligate now landlords to put in the publicity the last paid rent for all the short-term contracts. Among this region, you can just now see that Brussels has the most extensive list of required information with a particular focus on the energy performance certificates. It's not mentioned on the slide, but also in Flanders. And why is it not on the slide? That's because it's not in the article of Flemish housing decree. But in Flanders, you have a lot of other decrees. You have to look there for all the rules. But so in Flanders, there's also an obligation. I make publicity for a house or rental space. You have also the obligation to mention the EPC, so the energy performance certificate, into your publicity. So it's not on the list, but no, you have to check in other decrees to have all the information. Now, with these pre-contractual obligations, there come penalties for non-compliances. All three regions impose monetary fines if the landlord fails to meet these requirements. In Flanders, fines range from 50 to 350 euro, and municipalities can initiate future legal action. In Brussels, if there's any damage, tenants have the right to demand contract termination and compensation for damages resulting from incomplete or inaccurate information. If there's no damage proof, a judge can also limit tenant charges to the information provided if the information that was provided is incorrect. So it's important to respect the information, the pre-contractual phase, and give all the correct information to the tenant. Also in Brussels, when there's a lack of respect for the rules, you can have a fine by the government. It's going from 50 to 200 euros. Same thing in Wallonia. Also there, if you lack the rules of publicity, you can have a fine, administrative fine of the government, but the tenant can also go to court and ask the judge to make a decision. Now, pre-contractual information, let's see. So landlords have to give you a lot of information, but they're all in return allowed to give them a lot of information too, in order to examine if they do agree with the candidate that will eventually sign these agreements. So what can you ask as landlord of a potential tenant? If you look in Flanders, there's no provided specific list of documents that a landlord is allowed to request. The Flemish housing decree restricts landlords to asking only the documents necessary to fulfill their tenancy obligations. Now, what necessary obligation means is not always clear. One example are salaries or other revenues. All landlords are allowed to demand them to ensure that you're able to afford the rental payments. In general, the judges take a look at the Brussels legislation that is a lot clearer in this regard. So I always recommend landlords, if they're not certain what kind of information they can ask in Flanders, let's take the list of Brussels, and that's the information that you can ask for tenants. But the most important thing is the information that you need to check if the tenant will be able to fulfill all his obligations. So I'm speaking about Brussels and the list of Brussels, and just until January, we could find a list of Brussels into the Brussels Housing Code, but like in Belgium, nothing is easy. They changed it, and there's not longer an article about the kind of information you can ask into the Brussels Housing Code, but you have to check another Brussels code. That's the code, Brussels Code for Equality, Non-Discrimination, and the Promotion of Diversity. So we have to check there. It's the same article as before into our Brussels Housing Code. And in Article 32, there's a list of information that you can ask. So surname, first name of the prospective tenant, a means of communication, a document that makes it possible to establish the identity of the tenant and also its ability to contract. The number of persons comprising the household and the number of financial resources available to the tenant or its estimation. Important, you can't ask all this information at the first time you see the tenant. No, there's a specific time on which you can ask for this kind of information. No, in Brussels, a tenant or prospective tenant has the right always to go visit the apartment. So if you make publicity and there's a prospective tenant, you're obligated to let him do the viewing of the apartment. And before the viewing, you can only ask for the surname and the first name of the tenant, a prospective tenant, and a means of communication. At that time, you can't ask for a card of identity. You can't ask for the proof of any revenue. No, only name and how can we connect, how can we communicate. After the visit, when the prospective tenant wants to apply for the apartment, only then, in support of the application, you can ask for the number of persons comprising the household, so you can check if that kind of family will suit with the apartment. And at that time, you can ask for the amount of the financial source available to the tenant. Only at that time. And then when you're writing, the drafting and concluding the rental agreement, at that time, you can ask for identity and to check the ability to contract. Now, Wallonia has also set a list of documents that landlords are permitted to request. And these lists are quite similar with the other regions. Most of these are more or less intuitive. We have the names and the means of communication and the proof that the potential tenant is capable to conclude contracts. All information that can be demand or the financial resources to ensure the ability to pay the rent and the amount of persons in the household. The number of persons, like I said before, is crucial, so not too many persons will live unregistered at the address. So we have all our pre-contractual information. We're going to put it into a lease agreement, and in the 3 regions, you have specific rules about the form of the housing lease. So at the minimum, the identities of the parties, the start date, and the duration of the rental agreement must be included. Required information is concerning identity difference, depending on if the renter is a natural person, meaning human being, or a legal entity as a company, for example. For natural persons, the necessary information are the name, including their first 2 given names and then the current place of residence. Also, very important, national register number. Don't forget to put it into the contracts. It's important for your registration, but also if you're going to proceed, if you have to go to court, you have to have the national register number. If someone does not have a national register number because they are coming from another country, for example, then mention the date and place of birth, put it into the contract so we can find the tenants. In agreements with legal entities, their legal name, their register office, and their enterprise number are required. Enterprise number is assigned at the inscription of the enterprise, and if this number is not already assigned, it has to be added later at the bottom or at a separate additional declaration. But normally, if an enterprise wants to sign, he has to exist, so an enterprise number must be there. Starting date and duration are also important, and so it's important to put it into your lease agreement. If you're going to look specifically for Flanders, you have to also refer to the vulgariserende toelichting. It is a simplified, easy to understand explanation. You have the link on our slide. It's on the website of Vlaanderen. So it's an explanation of the housing rental legislation, explains to tenants, but also to landlords in not so legal words, so everybody can understand it. And it's designed to help non-lawyers, such as tenants, landlords, to understand the rights and obligation. It's not need to add it to the agreement, but you have to refer to it. So you don't have to attach a lot of documents, but you have to mention in your contract where the tenant or the landlord can find it. Let's see, for Wallonia, it's like the same list for Flanders. You have identity, dates on which the contract will start, duration, type of rental, description, rooms, parts, and also date of the last PEB certificate. But Brussels, like before in the pre-contractual situation, Brussels has a little bit extra information that you have to mention into your form. Let's see, first of all, it's normal identity of the contracting parties, date of the rental contract, description, and the rental price, and like mentioned in our publicity, you have to mention also in your contract the reference rent. Then the number, the estimation number of charges, and if there are individual meters, you have to mention that also. But other than in Flanders, where you can refer into your contract to the vulgariserende toelichting, so the extra information, in Brussels, it's still obligated to put an attachment, appendix, to your lease agreement. And the name of this, it's not vulgariserende toelichting, it's the appendix of Article 2018, paragraph 5 of the Housing Code. You can find it at the site of Brussels, the housing website, so Brussels Huisvesting. So there you can find all the information. But in Brussels, you have a lot of models from your contract to all the letters that you have to send, and also the appendix of Article 218 you can find on the website of Brussels. Important so that you have to put it into your contract. When you do a lot of leases, like big farms with a lot of rental contracts, you can maybe put it on your website and mention a link in your contract to the website so you can avoid a lot of paperwork. I know a lot of contracts are also signed with DocuSign or another way, especially with expats, you work online. So don't forget to mention this appendix. Maybe if you send all the documents, let it sign also that the tenant has received this kind of information. Now, since November 24, so last year they made a lot of changes to the Brussels Housing Code. And one of them is that it's now also legally established that any clause in the rental agreement or its annexes that outright prohibits the keeping a pet in a rented property, it will be considered null and void. So you can't put in the contract that they can keep a pet or another animal. The rental agreement can make keeping the pets conditional upon the absence of nuisance, or in particular any form of aggression, like a big dog or Rottweiler, or limit the number of types of animal that may be kept based on reasonable grounds. Because when we're talking about pets, I'm thinking a cat, a dog, but some tenants are thinking about a crocodile or other exotic animals. So don't put, when you're the landlord, don't put an article into your contract to that there are no pets allowed. No, think about a clause where you you can allow pets, but maybe one pet and only a cat or dog or another kind of small animal, but no aggressive animals or exotic ones. Also, in Brussels, since May this year, you see in Brussels they keep busy with new rules. But since May this year, so now 1 month and a half, landlords are not allowed to ask disproportionate rent. So let's see what is that now. As a renter, you are allowed to file for revision of its rent price. To know what's now expensive or not, or disproportionate rent, you have to look at the reference rent, what was mentioned in the publicity, and it was also mentioned in your contract. To find reference rent, you can look at the website of Brussels. There you have a tool. You can fill in some questions, and then you can see if your rental price is disproportionated, yes or no. And we're talking about a disproportional rent when your rent price is 20% higher than the reference price. When is that the case? You can ask a commission for advice to see if there are some circumstances that allow or motivating the higher rent. But if you're the tenant and you don't want to pass by the commission, you can also go directly to court. When you're the landlord and you're now seeing that your rental price is a lot higher than the 20% margin that is with the reference price, don't worry, you have the commission. You can motivate your rental price. And even if your price is too low, you can ask for a revision to ask for a higher rental price. But if you're now looking for new tenants and you're seeing for what kind of price I can ask, watch out with rental prices that are 20% higher than the reference price. If that's the case, you have to motivate your rental price. Now, registration, like I mentioned before, it's a particular system for Belgium. If you signed your contract and you want to move into the property, your contract has to be registered by your landlord. So it's always the obligation for the landlord. And registering the lease has advantages for both tenants and landlord. Once the lease is registered, it is binding on everyone, also third parties. The agreement must be observed even by those who have not signed it. So a new buyer or a new landlord, they must respect it. Important, you have the federal rule to register your contracts. And the federal rule is that you have to register your contract within the 2 months after signing. So a lot of people think after entry into force of the contract. No, it is after signing this agreement that the contract must be registered. So like I said, it's the renter's responsibility. And if your contract is not registered, it can lead to certain legal consequences. For example, in Brussels, indexation of the rent is suspended as long as the contract is not registered. But also, a tenant whose contract is not registered, he can give notice without giving a delay, without paying any damages. He can only send a letter, I give my notice, without respecting any delay. So it's important, big obligation for the landlord to do the registration on time. Important for Brussels. First of all, you have since January 1st this year, a system of double registration. So you have to register your contract federal on the website MyFin, and you have to register it on the website of Brussels, where you have to put in a lot of more information. So you have to give information about your rental price, habitable area, all the information that is in your contract or was asked in the publicity phase, you have to mention or give again to the Brussels government. So Brussels, you have 2 types of registration, don't forget it. And also different than the other regions in Brussels, The sanction that the tenant can give notice without giving any delay or without paying for any damages. In Brussels, the tenant can only give his notice and leave the apartment if he first sent a formal notice to the landlord to obligate the landlord to register the contract. So in Brussels, you have a second chance to register your contract before the tenant can leave the apartment. But no, in the meantime, as long as your contract is not registered, you can't ask for any indexation. Now, let's see for the condition of the leased property. So, as highlighted in my slides, each of the 3 Belgian regional legislations include a detailed checklist at the beginning of the surveys. The key point is to ensure every aspect is thoroughly described, especially any damage that may be present before the new tenant gets into the apartment. It is a guarantee that damage was already present when the tenancy started. So it's up onto the parties to decide who will create a survey. If no survey has been made, and that's an important one, it is assumed that the tenant has accepted the location in its condition when returned. So if you don't have your survey done before the tenant goes into the property, at the end, it will be very difficult to prove any damages. So it's very important that you do it. And that's also the reason why landlords generally always want a description. So a property inventory must be carried out in accordance with applicable legal provisions, and the survey should address any contradictions or disagreements regarding the condition of the property. It is to be conducted at the joint expense of the parties involved, unless otherwise agreed. The choice of expert to carry out the survey is left to the discretion of the parties. If you don't find an agreement, you can always ask the court to point out an expert. The survey must be conducted either during periods when the premises are unoccupied at the latest within the first month following the start of occupancy. I always recommend it, do it before you hand over the case. For properties located in the Brussels region, survey must also indicate an overview of consumptions, of figures, and numbers of meters. That's mentioned in the Brussels Housing Code, but it's recommended for the other regions also. There's also specifically a rule for Walloon, but it's like the same for Brussels and Flanders. Now let's see module 2, the common rules on the execution of the rental agreement. In this module, we will discuss who is responsible for the payment of the works, when these payments are due, and under what conditions the contract can be terminated, and the terms surrounding the termination in the 3 regions. Now, the principle in the 3 regions is that the tenant is responsible for minor repairs, resulting from use contrary to the intended purpose or good faith, and repairs needed to due failure to notice the landlord unless the tenant can prove that the landlord was aware of the necessary repairs in time without the notification. So it's an important one. A landlord must notify the tenant must be notify the landlord when there are problems or repairs due by the landlord. Repairs that are necessary solely due to aging or force majeure, overnight, are the responsibility of the landlord. Tenant's obligation to carry out repairs can be contractual limited or even excluded depending on the terms of the lease. You can always change the obligations for the tenant and put them by the landlord, but not in the other way. You can't ask the tenant to do more repairs than he's legally due for. And we'll see, we have both in Flanders and Brussels, there's a non-exhaustive list of minor repairs. And that includes both a list for the tenants who have established their main residence in a rental property and a separate list for student tenants in Flanders. And no, in that the lists in Flanders, it's only indicative, but normally not legally binding. But I can tell you the court will always follow that list. So in a kind of way, it is legally binding. And then you have Brussels. In Brussels, the list is binding and you're obligated to follow it. So in Brussels and Wallonia, the tenant is responsible for rental repairs as well as minor repairs and maintenances. In Brussels, repair due to age and force majeure are the landlord responsibility, just like into the Flemish region. And like I told you before, you have the non-executive list of repairs. In Wallonia, repairs resulting from use are the tenant's responsibility. Tenants are also liable for damage caused by fire, for which insurance is mandatory. And no fire insurance is obligated for the tenant in the 3 regions. So in Flanders, the landlord is required to maintain the property in such a way that it remains suitable for its intended use. Throughout the rental period, the landlord must carry out all the necessary repairs except for those that are legally the tenant's responsibility. And that's why you have all lists. In Brussels, the landlord is liable also for all repairs other than those explicitly assigned to the tenant. Again, let's check the list. And same thing in Wallonia, all the works that are not for a tenant are for a landlord. Now, regarding the rent price, parties are in principle free to negotiate in the 3 regions, but however, there are restrictions on rent for successive leases. So in Flanders, there's a restriction for student contracts with the same tenant. If you close a contract with the same tenant, you can ask for a higher price, even if the tenant is changing. No, so the same tenant, you can't ask for in a new lease for a higher price. In Brussels, for the short-term lease, like I explained in the beginning of the presentation, even there, when the tenant is different, you can't ask for a higher price. You only can end the circle of rent prices to when you are signing a contract lease, that's not a short-term, so a 9-year contract, then you can ask again the rental price that you want, but pay attention for our reference rents. So, like I already explained, in Brussels, there's also the indicative grid of reference rents, and that the reference rent you must include into your lease agreement. In Wallonia, the government also sets up non-binding rent price grid based on housing types and geographic zones using statistical rent levels. This grid takes into account features like room numbers, comfort, renovation status. It's like the same list of Brussels, and can be adjusted for specific amenities or inconveniences. It is updated annually using data from typical rental homes in Wallonia, excluding public, atypical student, co-tenant, and long-term rentals. And the government ensures public access to grid and provides clear usage guidelines. You have the link on the slides. Okay, for the indexation, it is a mechanism that allows landlords to raise the rent according to a specific index. In the 3 regions, indexation occurs once a year on the anniversary of the lease. So when the lease started, first date, and it applies to written rental agreements, and as long as the indexation is not expressly excluded into the contract. So when it's not mentioned in your contract, don't worry, you can indexate your contract, but it can be explicitly excluded. You have to send a written request for the indexation. And if you forgot to send it at the anniversary, you can return three months retroactively to ask for the indexation. Like I said before, in Brussels, to ask for the indexation, you have 2 other obligations. First of all, you have to register the rental agreement, and also the energy certificate must be communicated to the tenant before you can ask for any indexations in Brussels. The indexation formula, it's a federal formula. It's calculated by multiplying the base rent by the new index and then divided by the starting index. It's very easy if you go online. If you look huurwaarborg, indexation in Belgium, you have a tool by the government of Brussels of Belgium, and then by each region you can see what is the new rent that you can ask. The base rent is always the rent, the price of lease, excluding all cost and charge. And then you have the new index refers to the health index figures for the month presiding the anniversary of the lease effective date. And then the starting index, it varies by region. So in Flanders, it is the month presiding the month of the lease took effect, and in Brussels, it is the month, the contract presiding the month that the contract was concluded. So small differences. And in Wallonia, it's again the starting date of the contract. But if you use the tool of the Belgian government, it's very easy to calculate the new rent. So if you're going to see for the charges in the 3 regions, you still use Article 1728 Civil Code. Know that the Civil Code is undergoing some changes, but the same rule will apply in Book 7 of the new Civil Code, but the number of articles will change. But in our 3 regions, all the costs and charges imposed by the tenant must correspond to the actual expenses incurred. And these expenses must be clearly detailed in a separate statement of costs and charges, accompanied by supporting documents that prove the expenditures. A tenant has always the right to request a revision of lump sum charges or have the ask to convert into the actual cost. And if you don't find an agreement, it will be the judge who will decide. Now, what can a landlord charge besides the rent? Now, in Flanders, for residential leases concerning tenants' main residence, costs and charges related to the property itself are always for the landlord, while the costs and charges related to the use of the rented property are for the tenant. Property tax for the leased property in each region can never be put on to the tenant. Never for the tenant, always property tax, always for the landlord. In Flanders, the Flemish government has provided a list, again, non-exhaustive, of list of costs that you can ask by the landlord, by the tenant, so you can check always the list. No, for students, you have to ask an all-in rent, so you can't ask for certain costs. So also in Brussels, all charges and costs can be imposed by the tenant, except for the property tax, and same rule for Wallonia. Now, what can you do if you have looked for the end of the contract? End of the contract, you have to send a notice, because without any notice, our lease agreement will continue. And important for the 3 regions, if you send a notice, it only starts on the first day on the month that follows the month in which you give the notice. So it's not because we will send a notice on today, 19 June, that the notice will start immediately tomorrow. No, it will start on the 1st of July. So there's one exception when the tenant gives notice. For students, there are some exceptions when the contract is not already took into force, but the general rule is the next month. So don't forget it. Take it into consideration that you have enough time for your notice. And then there are specific rules about the tenant's debt. Like I said before, in Flanders, if you have an old contract, so contract before January 2019, you have to check the old rules in the Residential Act, federal one. There were no rules about the tenant's debt, and it were the heirs that have to take over the contract. Now with our new decree, Flemish decree, so only for our contracts starting from 1st of January 2019. There's a new system, as like the same system in the 3 regions. That's when the last tenant, when there's the debt of the last tenant, when there are multiple tenants, the lease will automatically terminate at the end of the second month following the death, unless the tenants' heirs have declared their intention to continue the lease within that period. But if there are no heirs that declared they want to continue the lease, it's now automatically ends. So you don't lose any rent after 2 months. You can immediately look for another tenant. If you now go see co-letting and co-housing, it's like a very popular form, but watch out. It's not because each region provided it in his rental laws that each house can be authorized to do co-housing. Watch out for all the rules administrative. But if you see, if you look at the rules of Flanders and Brussels, in Flanders, tenants, along with other persons who are living in the property as a main residence, can jointly request the landlord consent for that person to become a tenant. And if the landlord does not respond within 3 months, the tenants and the additional person can apply the court to have the individual added as a tenant, and it will be the court's decision. And at that time, tenants are jointly severally liable for fulfilling all obligations under the lease. The tenant that leaves, he will not keep responsible if the other tenants are not respecting their obligations. In Brussels, it's like the same system, co-tenancy, medehuur. It is possible, but also the landlord must agree for choosing this kind of system. It's also a system that the tenants can change more easy and don't have to fulfill the whole duration of the contract. I will go a little bit quicker because otherwise we don't going to have enough time. But there's a system, it's like the same one in Wallonia, but landlord and tenants must choose for this kind of system, where other tenants can join into the contract, but can give notice without that the other tenants must respect the notice. The other tenants can stay and one of the tenants can leave the lease. So there are other systems for the termination, also the notice period the tenant must give. Same rule for the 3 regions is that the tenant that wants to end his lease, he has to search for a new tenant and introduce a new tenant, or he has to prove that he searched for a new tenant. Otherwise, he can be kept liable for a period of 6 months together with the other remaining tenants. In Brussels, when you choose for a system of co-housing, medehuur, it's also common that the co-tenants sign a document. It's like acte de base, but for co-housing and medehuurpact, in which they explain some rules about the co-tenancy, like who's going to pay for the rent, who's going to pay for the insurance, who's going to put the garbage out. It's like when you have a condo, there you have also an acte de base basis act, and you're going to conclude the same document in Brussels. It's not foreseen in the other regions, but if you have a co-tenancy, it is recommended to make some housing rules. So let's go to a dispute resolution. I think we all want a rental contract to go on without any disputes with the landlord or tenants, but unfortunately, it is not always the case. And that's why I like to address you these topics. So now for the 3 regions in Belgium, it's always Justice de Paix that is the responsible court for all the lease discussions, even if it's commercial lease, rental lease. We don't look for the price or the amount in question. No, you always have to be justice of peace, and it is justice of peace located in the area where the property is situated. Note that any arbitration clause is not it's not accepted in Belgium, not in Flanders, not in Brussels, Wallonia. You can only choose for arbitration after you have already a discussion and both parties, after the dispute has arisen, can choose to go to arbitration. I don't recommend it in lease agreements because in arbitration it costs a lot more, and you don't get the opportunity to go in appeal. So it's better to go to the justice of peace. It's the price is not so high as an arbitration. Important, if you want to go to proceed, you have to send a notice of default, and only after the notice of default you can send in a request to the Justice of Peace, and normally it takes 2 to 3 weeks to have a hearing. But no, especially in Brussels, there are too many cases, and sometimes you have to wait for months before you have one hearing. After the hearing, if you can treat on the first hearing, it takes about 1 month to have your verdict. And if you want to execute your the judgment, you have to work with a bailiff. And the problem is also with the bailiffs, they have too much work, and it can take some time before you can really execute your judgment. No, in Brussels, the rules are more severe than the other regions, and they changed, I think now 2 years. You have specific rules that you have to also send a notice of default to the tenant, but you have to respect 1 month before you can go to court. So in other regions, it's a period of 15 days. In Brussels, it must be 1 month at the minimum, and then you get to go to court, but you don't have 2 to 3 weeks before you have your hearing. It's at a minimum 40 days before you can go to have a court date. So the delays are a lot longer in Brussels than into the other regions. No, in Brussels, there's also the right of forced refusal of the tenant. It's a specific rule, and it started since 6 January 2024. So there was a new ordinance that came into effect, and it's granting tenants a right of forced refusal when the property they rent as a main residence, only for main residents, and for not for short-term contracts. So when you have a tenant who is there with a short-term contract that's not already reformed to a 9-year contract, it doesn't count. It's only for all the contracts that are already for 9 years. There, the tenant has the right to buy the house before any other person. And it also means that to execute this right for supply, there must be a notice sent to the tenant with all the information about the sale, the conditions, and the price that you want for your house or for the property. There are some exceptions, such as sale between family members, sales resulting from corporate mergers or public actions. I don't going to waste too much time on this kind of topic, but you have to know that there is a right of forced refusal. So when you have a tenant or you are a tenant in Brussels, there's that right. When you want to buy something in Brussels and there's a tenant, watch out. Check it also that the right of forced refusal is applied, is respected, because the sanctions, the penalties are very high, even for when you're buying a house and there's a tenant in the house, and where the rules about the right of forced refusal are not respected. The tenant, even 1 year after that you already signed the contract and you passed by the notary, even 1 year later, the tenant can ask to put in your rights as a buyer, and you can still lose your property. So it's very important for the landlord, for the tenant, but also for a buyer in Brussels to check if all the rules about the right of forced refusal are respected. And then evictions in Brussels. There's a lot of Brussels, but Brussels has very specific rules. In Brussels, an eviction period has undergone also a significant reform. And I already explained that you have to send the notice and you have some delays and terms to respect, but no, there's also a winter moratorium. And that's a certain period. It's from November 1st just until March 15, that no evictions are prohibited. So the bailiff can't evict a tenant, even if you have a judgment. You can't evict the tenant, even if he's not paying. There are some exceptions, but not so much. You see there on the slide, when the tenant found an alternative house, it's almost never the case. Or when there's a risk for health or safety. And that's maybe one that you can use when the tenant's behavior causes a dangerous situation to make future occupancy impossible. Or the last one, if the landlord is facing a case of force majeure requiring them to personally occupy the property, but it's almost never the case. So no, from November 1st just until March 15, there are no evictions authorized in Brussels. You know, there's a compensation system, but it's not so much used. There's certain rules to get reimbursed by a solidarity fund if you can do the eviction in that winter moratorium. And now, to end our presentation, I have some tips and tricks for expats. First of all, provide a detailed description of the property at the start of the rental. I recommend with pictures, so you don't have a lot of disputes at the end of the contract, let's hope. Avoid using a vague or overly simply rental agreement. Use models, especially for Brussels, you have models that you can use so that everything is clearly written down and signed by both parties. As a tenant, you have the right to request that the security deposit, the caution, is placed on a joint account, so not on a landlord's personal account. And the security deposit is intended to cover damages to the property, not for unpaid rent. It's only after a judgment that you can use it also for the unpaid rent. And always control the identity of a landlord in order to avoid potential fraud situations. Not only from the landlord, also the tenants. We have already had cases that there was abuse of a tenant's identity, so check it. For tenants, don't pay cash. In Brussels, it's even you can't do it anymore. You have to mention a bank account into your contract. As a tenant, never pay cash, always use bank transfers. And understand your right to privacy. Landlords cannot enter the property without your permission or proper notice. Be wary of unusually low rent. Normally, if the rent is still low, that's because there are problems with the house. Don't assume verbal promises as binding. You have to mention it into the contract, don't forget it. And if the landlord promises to repaint or fix something, get it written before signing the lease. Know your rights about rent indexation and notice periods. Know your rights in general. And do not sign something you don't fully understand. So when the contract is in another language, in Brussels, you see a lot of contracts also in English. But no, if you go to court, it's only in French or Dutch that you can proceed. So that's why most of contracts are in one of the both languages. So just not in time, we are at the part of the questions. I will end. I will show you the last slides. So you have there all the information. Don't hesitate. Send me an email. You can phone me on my mobile phone. I'm not a lot behind my desk at the office, so use my mobile phone number. You can always contact me. Let's check in the chat box if there are any questions. As English is not an official Belgian language, our translated contracts legal. Like I said, just came to explain. If it's in English and it's signed, it is legal. But if you go to court, some judges are difficult. And they're asking for translation of all the documents that we want to give to the court. So then at that time, we have to make a translate document. What is usually common, if you have an English contract, normally there's also a Dutch or a French version, or you have both one contract with both of the languages. And we always put a phrase into the contract that the Dutch version or the French version is the legally binding document. But you can work with an English one that is signed, but if you have two types of contract and they're both signed, put in one of the contracts which one must be respected before the other one to avoid any discussion about translation or interpretation of the contract. I don't know if there are any other questions. We already passed time with a couple of minutes.
I trust we will receive the presentation, Ulrike.
Okay, now you can see me again. And I stopped sharing my screen.
Yes, welcome, Dave. And first of all, thank you so much, Ulrike. That was very all-encompassing and hugely informative.
Yeah, it's a lot of information in 1 hour. I can speak about, especially about Brussels, but for the 2 regions, I can talk about it all day, but we don't have that time. So if you have more questions about the right of first refusal or other topics, call me, send me an email, or we can do another presentation about one specific topic. I'm always
Fiona, can I have a very quick question?
Yes.
Before we close the session?
Yes, of course.
Yes, thanks very much. I'm wondering about the abusive rent regulation. So I understand that will certainly apply to all leases that have been signed till the 1st of May. When a tenant signs a lease now with the new template, will they commit to rent a place for a certain price? Can we then assume that it's all sufficiently documented for them to no longer be allowed to go to the Commission? Or can they still go back on an agreement they have taken en connaissance de cause?
Yes, they can always go to the Commission or to go to court because it's an obligation of the landlord. That they can't ask for a rental price higher than the 20% of the reference price. So I wish it was another rule, but
so even if they've signed
a contract and he's aware that his rental price is a lot higher, he can always go to court or ask for the Commission for advice. But that's why I recommend landlords, if that's the case, find a motivation, because maybe you have it's a new house or you have other services that you give. So if you have a motivation, maybe we can ask the Commission to authorize your rental price. I went to the website yesterday of the Commission. There were not any advices already there. I sent an email, so when I have more news about their advices that they give the Commission, we will make a newsletter about it, and we will inform everybody by our website or by our social media.
Okay, thank you.
Thank you. Well, if there are no other questions, I think it's now getting close to closing time of this extremely interesting webinar, and makes us think that the job has suddenly gotten much more complicated than we used to think, but it's actually the case. So it's important to have all the relevant information. So thank you again, Ulrike, for this very, very interesting session.
Okay.
Thank you. And thank you everybody to attend.
Okay.
Fiona, you want to add something?
Bye.